Hello and welcome to Friday Live. I am your host, Strata lawyer Amanda Farmer. We're going out live today to the Your Strata Property Facebook page. We should be going out to LinkedIn as well and out to YouTube. This is our catch up, our wrap up, our time to spend together having a chat about what's important in Strata, what's been going on, a time for you to relax even after a hard week in Strata and pat yourself on the back for getting through it. Do something nice for you. That's how I look at Friday Live. I always look forward to being here and spending time with you. Today's rolled around really, really fast. As you can see, not in my country home, in my usual home studio, I might call it, in country town Mudgee, which is where I live. I am in the Big Smoke today. I am in my city apartment, lucky enough to be here for just over a week. I came in yesterday to celebrate the Women in Strata end of year party, join my fellow women professionals, strata managers who have been working hard all year, serving owners, also catching up with service providers, lawyers, engineers, tradespeople who attend our Women in Strata parties. We were at the Ivy Penthouse last night, which was a whole lot of fun. I met many of you strata managers who tune in regularly to live. Some of you do my exclusive online trainings that I do for members of our online community. And you've seen a lot of this, but we've never actually met in person. So it was so nice when you came up to me and introduced yourself and told me that you love listening to the podcast and you love being here on Friday Live. Some of you said, I don't post, but I'm a bit of a lurker. I always tune in and listen to what's going on, what's hot in the week in Strata. So thanks for that. And if you lurkers are here, feel free to say hello. I'd love to hear from you. Many of you are coming on in saying hi. Cheryl's here saying hello. Hey, Cheryl. Shana is here. Hey. John is saying big night. Look, I'm old now, John. I don't really have big nights. No. And Bridget's saying you look very fresh and sparky after a big night out. Yeah, look, it's a big night in that I usually live in a quiet country town and do a lot of online work. So I don't do a lot with a lot of people anymore. So just being here, being in town with lots of people around can be a little bit exhausting. But yeah, I don't drink very much, if at all, anymore. So I'm one of those annoying people who just sort of sits on the soda water all night and gets up the next morning and goes, I feel fabulous. Let's go for a walk at 7 a.m. So perhaps, yeah, that's why I'm a bit bright and sparky. I'm also excited because it's Friday Live and we've got lots of important things to talk about. I'm already seeing lots of eyes coming in here bright and early. Perhaps you've seen my email. Perhaps you got my email this afternoon giving you a bit of a hint as to what we are going to be talking about. I know last night, one strata manager said to me, Amanda, I always enjoy your sessions, but I really like it when you get into the juicy stuff, when it's an issue that maybe is new or an issue that hasn't been determined by the tribunal before, and maybe there's two different ways of looking at it. And as strata managers, we might have a debate about what the right way may be, looking at cases and the different ways that the tribunal has applied the law. That's what some of you have told me you really like. And it just so happens that today I got a doozy for you. I have one of those interesting, challenging topics to cover, and we are definitely going to get into that. Megan is here saying hello. John is saying, have you seen the study from the US that warns watching people in Zoom too much turns you into a zombie? Haven't seen that study, John. That is not an invitation to post a link to it here. Don't know if I need that one right now, but thank you for the heads up. Patrina's saying, hi, Amanda, I made it. Also, hi to all the bullies in the scheme who keep trolling me on social media. Oh, that sounds horrible, Patrina. I'm sorry that you're going through that. It's not nice at all to be bullied. Perhaps related to our topic today. Our topic may have a little bit of that context. Is there some bullying perhaps going on in the community that we're going to have a look at a little bit later today? Welcome, everybody, and many more of you coming in. Feel free to say hi. Podcast this week. Rena and I went out on the podcast this week. We were talking about a few issues, the signing of contracts for building work, and Rena was letting us know what strata managers really should be looking out for. She was having a bit of a frustration where the quote that was proposed by a contractor was in the name of a company that appeared to be unlicensed, and she was being pressured to sign the contract to get the work underway, and she was digging in her heels, as Rena likes to do, is good at doing, and making sure that she was acting in accordance with her legal obligations, making sure the owners corporation was meeting its legal obligations and there was no unlicensed contracting going on. If that's something that you have come across as strata managers, as owners, have a listen to this week's podcast episode. There might be a bit of clarity there for you. Rena also talked a little bit about an NCAT case, which she's partway through and had an early win there for a building. And it led into a discussion about unrepresented litigants and how the tribunal may assist unrepresented litigants, those who are appearing in the tribunal without a lawyer, to argue their case, and may also, may also from time to time make clear to an unrepresented litigant when the writing is on the wall, when a case is just not worth arguing or not worth defending. I found in a recent experience that the tribunal can be quite helpful in sharing that information. So that's in this week's podcast episode. We also talked about the new age of electronic record keeping. I'm saying new with quotation marks there. We should all be across electronic record keeping by now, but apparently we're not, because part of our strata legislation reforms that are underway here in New South Wales, or are being proposed, that legislation hasn't started yet, is seeing owners corporations being forced to, legally required to, keep electronic records. So Rena and I were covering that one off as well in this week's chat. And finally, the rush to access a share of the New South Wales government's $10 million EV charging grant. I spoke to a concern that was raised with me by a listener who felt a little bit pressured by the strata management company to take part in this grant, and asking whether buildings shouldn't be taking a holistic approach and looking at all the upsides and downsides of EV charging, and making sure that all risks were being addressed in a building, and that everyone was aware of any insurance implications, fire risks, especially with the media that we've had lately about e-scooters exploding in apartments, EV fires. Rena and I had a bit of a chat about that and how she's communicating some of these issues to her buildings. And I have had a couple of listeners in touch with me, as you often like to do, and we might be talking about something a little bit controversial on the podcast, and let me know your thoughts on that particular issue. I'm going to come back to a helpful article that has been shared with me on that topic that you might want to have a look at. Before I do that, I'm going to head over to these comments and welcome in those who are here saying good afternoon and hello. Sean O'Day, great to see you. Good afternoon to you. David's here from Neutral Bay. Hey, David. Anthony's here. Hi, Amanda. How are you going? Good. I hope you're well. I hope you're well too, Anthony. Thank you very much for those wishes. All right. Don't think I've missed anybody yet. Yes, we are. We are going to get to the topic that I was alluding to in my email this afternoon. I think I recognize those eyes here to make sure you don't miss out on that discussion. We're definitely going to get there. Before we do, I've said that this discussion that Rena and I were having about EV charging and potential risks of having EVs, not just vehicles, but e-scooters as well, in our apartment buildings. We were talking about that on the podcast. And I was lucky enough to be contacted by Michael Ferrier. Michael Ferrier from Ion Property Inspections. Michael's been a past guest here on the podcast. I think he's been here on live as well, talking very helpfully, very eloquently, as Michael does, about the inspection of books and records and the kinds of things that he's looking for and his team is looking for as professional strata searchers. And Michael said, thank you for the discussion that Rena and I had on the podcast about EVs. And he raised this question. He was wondering, having listened to that discussion, what the relative risk of EV fires versus petrol or diesel cars is. So how much more likely are EVs in particular to catch on fire when compared to petrol or diesel cars? And I think he might have done a little bit of Googling about that and came up with a reasonably recent article that appeared in The Conversation. And I'm just going to share that one with you here on the screen. We've got a link for you as well that is going to be popped into the comments. The headline on this one: electric vehicle fires are very rare. The risk for petrol and diesel vehicles is at least 20 times higher. So there you go. So Hussein Dia, Professor of Future Urban Mobility at the Swinburne University of Technology, is the author of this article. It's a September 2023 article. And it came in the context of 2 EV fires reported in Australia in that week. 5 cars were destroyed after a lithium battery ignited in a car parked at Sydney Airport on Monday. Firefighters believe the battery had been detached from the car because it was damaged, and there was another fire the same day. Despite these incidents, EV battery fires are rare. Indeed, the available data indicate the fire risk is between 20 and 80 times greater for petrol and diesel vehicles. Fire risks are also greater for electric scooters and electric bikes. However, battery fires do pose particular problems, and that goes on later in the article to talk about how those battery fires are actually really difficult to put out, and they can often reignite when it looks like they've already been put out. So I don't know if there's any adjustment in that data or adjustment in that research to take into account the number of EVs that are out there versus the number of petrol or diesel vehicles. But this is part of this holistic approach that I was recommending on the podcast, doing this kind of research to understand what the real risks are, indeed what the benefits are, and making a decision as to whether those benefits do outweigh the risks when you're looking at investing in implementing EV charging in your building. So I'm going to stop sharing that one for the minute. And there is a link here that's gone into the comments. Yeah, Shauna said, yes, but how many more petrol and diesel vehicles are out there? Yeah, so have a look at the article. I'm not sure that the research adjusts for that one, Sean, but definitely a very good point. John is saying, what about some planned new hydrogen fuel cells for bikes? I hear they may be explosive with no added agent to be able to smell leaks. Oh my gosh, that sounds terrifying. Let's put that one on the shelf for the minute, John, and not get too panicky if we don't need to. Olivia is saying hi. Hello there, Olivia. Bill and Ben saying, what's the fire risk from walking? Not a lot of people spontaneously combust. Is that your chosen method? Is that going to be your chosen method of transportation there, John? You're going to be walking rather than any kind of vehicle. I do like that. When I am here, this is what I love about apartment living. So this is my apartment that I come to when I'm in Sydney. When I'm here, I walk to the shops, walk to breakfast, walk to the train station, go to the park. If you're lucky enough to be in an area where all of that is possible for you and you live in an apartment, then I think it's a wonderful, wonderful lifestyle. David saying, would a bylaw banning charging e-bikes in apartments be considered harsh, unconscionable, or oppressive? Yeah, really good question, David. And I think you might have picked this up from Rena in that podcast episode. From memory, I think she was saying she's got a building who is thinking about imposing this kind of bylaw. Look, when we think about bylaws, we come from the perspective of what problem is this solving? Is this bylaw going to preserve, protect other occupiers' use and enjoyment of their lot or the common property? Is it the type of intervention that is necessary that can't really be achieved another way? All of those principles that, at least in New South Wales, were enunciated by our Court of Appeal when looking at the pet ban in the Cooper case and looking at what is it that makes a bylaw harsh, unconscionable, or oppressive. Do we need to go so far as to ban people from doing things in order to protect others? And it might be the case that in order to be safe, in order to address these risks, the only option is to ban the charging of e-bikes and e-scooters inside apartments. I don't know the answer to that question. And sometimes you do need to go to a technical expert, not a lawyer, somebody who has the expertise to look into these risks, whether upgrading power supplies and using particular chargers. I think it actually says that in this article that I shared with you, the e-scooters and e-bike fires are happening because it's the wrong charger that's been used, that's plugged into a normal outlet, which shouldn't happen. If all of those things were addressed, maybe the bylaw should go to regulating the use of the power supply, regulating how the charging happens. Maybe that's the less interventionist option, and a bylaw that just blanket bans something like e-bikes and e-scooter charging inside apartments. Maybe it would be harsh, unconscionable, or oppressive. But if you've got an expert saying, look, this is really the only way to ensure safety and to prevent or reduce to an acceptable level the risk of fire, then maybe a ban is okay. So that's my it depends. That's my very typical lawyerly it depends answer to that, David. But I do think anyone who's looking at, installing, implementing, in any way regulating the use of EVs or e-bikes or e-scooters, particularly by way of bylaw, it is almost a necessity to get some technical advice, some technical expertise of some sort to either make sure that it is able to be facilitated in a safe way, or to give you some parameters around which to draft your bylaw. And then, of course, you bring in the lawyer who can then get that drafting right for you and apply that test of whether whether a bylaw is harsh, unconscionable, or oppressive, depending on what the advice of the experts has been. Bill and Ben saying tough, if not impossible, to police. It depends on the community, I would say, Bill and Ben. There'd be plenty of high-rise communities out there that know exactly what's going on. People know exactly what's going on in other people's apartments. You know who's got the e-bikes. You know who's got the e-scooters. There are some people living in Strata that just seem to know precisely what passes through the lift and the corridors at all times, even without CCTV. So it is a good question, though. If you're going to put in place a bylaw, is it something that can be monitored? Is it something that can be policed, if you like? Sometimes the point, I often say, the point of having the bylaw is not so much that it's there as an enforcement tool, but it's there as a standard setting. It sets that standard and that expectation with the idea that 90%, 95% of people will comply with it simply because it exists. And it might be a small proportion that attempt to get away with a breach because they think they can. John saying, "My vacuum cleaner runs out of chargeable battery, electric drills, tools, toys, the list goes on." All right, so hope that helps you there, David. That is a good question. I'm sure there's many others who are asking it. Do head over and have a listen to this week's podcast episode. It's episode number 386, if you haven't caught that one yet. And thank you, Michael Ferrier, for providing, excuse me, one moment. Do you know what I've been doing? Something I should never do before Friday Live. I've been eating peanuts. When you eat nuts before you go live on video, on mic, it's not a good idea. Get nut shards. So excuse me if I need to take a few sips. Thank you, Michael Ferrier, for sharing that article in the conversation. It's how we all come together and learn more about these important topics. Okay, now we are going to turn to an issue that I'm going to attempt to navigate for you very carefully. Now, if you received my email this afternoon, giving you a little heads up about what we're going to be diving into today, you will have read my words, which were along these lines. Unlike some people who may have popular online platforms, many of them much more popular with much wider reach than this one, I don't consider this, the Your Strata Property page, my LinkedIn profile, our YouTube channel, the podcast, I don't consider these places to be platforms for sharing or debating political views or for, frankly, discussing any issues other than those arising in the context of strata and community living, and specifically strata and community title law. And I can tell you, today is not the day that this is going to become such a platform. The issue that I am now going to unpack for you and invite your views on is, in my view, strictly an issue of strata law. And to the extent that it might relate to or arise from one person's expression of their political view, I do ask you who are tuning in, whether you're here live or you're catching the replay, please do not divert the discussion away from the strata issues. We're not here to talk about politics, save for the general unavoidable references that you're going to see. We're not here to talk about religion. We're not here to talk about war. And should that happen, my team is closely monitoring and moderating the comments on all of our platforms. So any off-topic comments will be deleted. Users will be blocked if it's determined that that's appropriate to ensure the safety, the harmony, and ultimately the ongoing operation of this online space. All right, so having been the headmistress and laid down the law there for you, let's move into our discussion. Today, I was contacted by a person who is an owner-occupier in a strata building. Now, this person has consented to me sharing their story with you, sharing the photos that I'm going to share with you. This owner has had a visitor to their home recently, and that person has a vehicle, a car, and that person has been parking their car in the owner's designated garage space with the owner's permission. So the owner hasn't got a car in that space, visitor is there visiting, and owner says, yep, sure, no problem, come and park in my space. No issue with that. Now, after somebody saw this particular car in the garage space, the strata manager has directed the owner of the apartment to ensure that their visitor's car is no longer parked in the garage space. What they say is the car can be parked in your space if the decoration on the paintwork is removed. So there's something on this vehicle that is causing concern to some others in the building. Now, this owner has shared with me some snippets from emails from the strata manager. There have been a couple of emails, I think, over the last day or so. And the strata manager says, I've received several complaints in relation to a visitor to your lot number X. Attached are photos of the visitor's car in question. So somebody has taken these photos. They've then been given to the owner via the strata manager. There's an acknowledgement in these emails that the garage space is lot property. It's not common property. And there is a direction that the car should only park in the garage space if the writing that is on this vehicle is removed from the vehicle. And there is a warning in, I think, the latest email that failure to do so, failure to comply, may result in further action from the owner's corporation. So that's the background. That's the lay of the land. Do you want to see some photos? I've got to show you these photos so that you can understand the context here. I'm going to share with you, I think I will share that entire desktop for you, will be the easiest way to do it. We'll get rid of this article. And I'll share with you, first of all, this. Now, that's going to be hard for many of you to see, but this is a photo taken through the garage door. So this is a motorized garage door that goes up and down. The vehicle's in there. I appreciate you cannot see the writing that is on that vehicle, but you can see that there is some writing on it. So someone's gone right up there to the grate and taken that photo. And there's a point in showing the photo in this way. You can't actually see the writing when you're right up against the lot's garage. So it's kind of a semi-enclosed, or enclosed, I would say, enclosed garage space there. I've got another photo for you. This is also taken from a similar position, just front on. You can see a few words there. You can see Palestine, you can see "will be free," exclamation mark. Still very hard in that dark light to see exactly what is there on that car. Now this photo, once again, taken by somebody. I think the owner's not sure who it was taken by, but this is not in the garage. This is on the public street out the front of the building. And I think the purpose of this being taken and then provided is essentially to record what is actually written on the car. Now, some of you will be able to see that. I know some of you will be listening and may not be able to see, so I will tell you what the writing is. It says, "Ceasefire now, end the occupation, Greens for Palestine, Viva, Viva Intifada." And Greens for Palestine, I think, is on the back of that car as well. So that is the decoration, that is the paintwork, that is the writing that is on this car. And I think in my email this afternoon, I may have said I describe these as political slogans that are on this car, that is being parked by the looks of this, sometimes on the public street in front of the building, sometimes in an owner's garage space that is lot property. And you will have seen from those earlier pictures, I'll show you that one again, that you really need to press up against the door, the roller door there, to be able to see anything on that car. Alrighty, so you've seen those photos. I can see Amanda is here saying, unenforceable. Unenforceable. Interesting. This is the question. These are the questions, I suppose, that this owner was contacting me about and asking me about. Can an owners corporation direct what state, what shape a car has to be in order to be parked in a lot owner's own space? To read what's written on the car, you have to look pretty hard, as we've seen, through a door, a garage door, which I'm told is always closed if there's a car in there. And you remember that the allegation, I suppose, that's been made, or the criticism or the concern that's been raised, is that these statements are offensive. They're offensive. And I think the Strata manager's email was, there's a number of residents have complained about this particular car. I imagine the car is leaving the space from time to time and then maybe being parked on the street. So there is a time when it goes through the common property, I guess, but otherwise it's in a lot owner's personal space. John is saying, not if it's a democracy, so not a problem if it's a democracy. I think I read that as John. Something to add here, which is very concerning to me, and it's part of the reason why I wanted to bring this issue here, to talk about and consider the actual law, bring this back to law, bring this back to what are the legal avenues that may be available to an owners corporation. I'm told that after this email was sent, after this owner was told to only park the car here if it doesn't have this writing on it, the power to the garage was switched off. Just that garage, the power was switched off, flick of a switch it was apparently. And there was also what I'll describe as some rubbish that was thrown onto the back terrace of this owner's apartment. And from the owner's perspective, these were deliberate acts in intimidation and an attempt to perhaps send the message that, hey, if you don't do what we're directing you to do, then this is the kind of behaviour that you're going to be subject to. So, does the owners' corporation have a leg to stand on here? Do they have a legal right, a legal power to dictate, to direct what it is that an owner does inside their lot, what an owner parks inside their lot? So I would start with the bylaws. What does this building's bylaws say, if anything, about this particular issue? And I don't know what this building's bylaws say. I'm going to speak to model bylaws and things that a lot of you will probably have in place in your own buildings. There's probably a bylaw about the external appearance of a lot, or things that may be inside a lot that affect the external appearance of a building, and things that are not in keeping with the external appearance of a lot or of the building may not be permitted without consent. Something like that, fairly general terms of a bylaw. Query whether parking a car inside a private garage space that has writing on it that can't really be read from outside the garage space or indeed outside the building, query whether that is an impact on external appearance. I don't think it is. I think it would be a pretty long bow to draw there. There may be a bylaw about behaviour on common property. This is a car that's parked inside a lot and otherwise parked on a public street. As far as I can see, there's no issue with any behaviour that might be happening on the common property. I'm seeing a comment from Glenn, and this is where I am going next, Glenn. Section 153, says Glenn, requires lot owners and occupants in a strata scheme not to use or enjoy their lot or permit it to be used in a manner or for a purpose that causes a nuisance or a hazard to other lot owners and occupants. Yeah, so I had a look at section 153 as well. And I have to say this section has been front of mind for me at the moment because I'm working with a client who is bringing proceedings in nuisance in the tribunal. In that case, relates to smoking, cigarette smoke and smoke drift, which is one of those identified areas, activities that may be a nuisance under section 153. And the legal definition of nuisance is that there must be a substantial and unreasonable interference with someone else's ordinary use of their property. So I think if this owners corporation was thinking that they might want to go down the section 153 route, I think they may have a difficulty actually proving that parking the car inside the garage or even driving the car through the common property was using the lot. And as you've reproduced there, Glenn, it's about the use of the lot, using the lot in a way or for a manner that causes a nuisance or a hazard. I can't really see that it would fall into the category of hazard. So I think once again, that would also be a hard argument to make going down the nuisance path. John's saying, yes, I'm always affronted by nuisance vegan signs. One of our neighbours has. This is the thing. This is the thing about signage and slogans and political positioning in our strata schemes. It's something that is reasonably common, as I understand it, through my Googling and through hearing in the media a few years ago in the States. Quite a common problem in the States where they have large master planned communities, homeowner associations, a lot more people living in far bigger spaces than we have here in Australia. And there is this question of signage and flags. And what I was thinking about in the media from a few years ago, the Black Lives Matter movement, and there were signs and there were flags, and there were concerns raised by some homeowner associations and those leading them about the legality of that and the impact on appearance. And there's a real tension in the US because they have, enshrined in their Bill of Rights this right to freedom of speech. So it becomes quite a hotly contested debate over there as to whether there can be signs and things. I do agree that if there were signs up, election signs, for example, up in a window of an apartment building, and that was affecting the external appearance of the building, you may have an enforceable bylaw there. If there were signs put in a front yard, whether it was common property or whether it was indeed somebody's lot property, and again, that was affecting external appearance. I think in Australia, we generally come back to that question of, are we affecting the external appearance of the building? And that can be the case for sale signs and for lease signs that have been up for a period of time that is in excess of what's needed. So that was by way of addressing John's question there, or comment there about signs. So yes, all of this discussion can be as relevant to any kinds of signs. I'm actually told by this owner that this owner regularly keeps large signs in their garage, political signs, particularly when there's a local election happening or something like that. It's in the nature of this person's professional work that they have certain signs up for political parties inside their garage just by way of storage. And that's never before been an issue. It is this particular vehicle, the particular slogans on this vehicle that is causing the problem, apparently, for this community. And I'll get to the question of who exactly it might be causing a problem for in a moment, and the power that they seem to have to direct what the Strata manager does. Bill and Ben is giving me a Schedule 3 of the Strata Schemes Management Regulation. That's where our model appearance bylaw is. Thank you very much, Bill and Ben. The owner or occupier of a lot must not, without the prior written approval of the Owners Corporation, maintain within the lot anything visible from outside the lot that, when viewed from outside the lot, is not in keeping with the rest of the building. Yeah, so I'd say most buildings would have that bylaw. I don't think this car parked inside the lot is in breach of that bylaw, especially when you gotta really almost enter the lot to be able to see what the writing says, and then query whether it's not in keeping, writing on the vehicle, whether it's not in keeping with the rest of the building. Stephen's saying, if you don't like it, look the other way. Yep, that's one way to deal with it. Indeed, Stephen. John is saying smoke actually goes physically into the property and degrades lifespan. Yep, that's say why it is an identified nuisance under Section 153, John. Henry saying, hi Amanda, would Crimes Act Section 93Z regarding inciting hate speech override the bylaws? See, this is a tricky one. I've thought about this too, Henry. In my limited hours that I've had pre-Friday Live, I have thought about that one. What I want to do is I want to bring back those words, okay? Because I want to address this issue of what we're really saying here, and whether we do clarify this as hate speech. I'm not a criminal lawyer. I don't. Oh, choose the screen. I don't know exactly what that section of the Crimes Act says, Henry, how it's interpreted and how hate speech is defined. But there's a question, I think, around standards and whether there is certain conduct that just by its nature, or certain publications that just by their nature may be illegal or may be unacceptable. I think if we're talking about sexism, racism, violence, and you talk about their inciting hate speech or perhaps inciting violence, then it might be a place for an owners corporation to think about if they are suffering this problem, I guess if you want to call it a problem, think about whether they should regulate it or not. Sexism, racism, violence. To me, when I have a look at these words, to me, they are political statements. They are political statements. And that may well be in the eye of the beholder. But I do think that if a court or a tribunal, and that is indeed what I attempt to do when I'm assessing a situation, apply the lens of the court or the tribunal, what would they do? How would they unpack this and look at each of those statements? Something like Viva Intifada. So I've gone over to Wikipedia, the source of all good, reliable knowledge, Wikipedia, I say, tongue in cheek, to understand what that word means. And it's an Arabic word, and apparently it means rebellion or uprising or a resistance movement. It's a key concept in contemporary Arabic usage, referring to an uprising against oppression. And apparently in the Palestinian context, the word intifada refers to attempts to shake off, quote, shake off the Israeli occupation of the West Bank and Gaza Strip. And it was first used to connote aggressive, non-violent resistance. And that came from Palestinian students in the struggles in the 1980s, where they wanted to adopt a less confrontational stance and actually have a non-violent protest. So I think you do have to unpack each of those words to be able to take the position of whether this is an incitement to hate speech or an incitement to violence, or in some other way criminal, or whether they are political statements and political slogans. And I think that changes the way that you might approach or attempt to approach the solution to the problem. All right, heading back to those comments. And making sure that I don't fall into any traps here. Okay. Stephen's saying he doesn't think it incites hate speech. Yeah, okay. This is the thing. While I say very openly, these are matters of strata law. We're looking at what the law says. We're looking at strata and community living. Inevitably, we do sometimes have to make these judgment calls, look a little bit closer at what's going on in our broader community, do some research and decide not only what we are comfortable with or least uncomfortable with, but where we think we can most fairly, equitably rely on the law and use the law to regulate an issue. I think that it would be a good idea for this building to play out perhaps what might happen if they were to attempt maybe to enforce some kind of bylaw. I'm not quite sure yet what that bylaw would be, or maybe they want to go down the Section 153 route. If they were to play that out and the owner of the unit was to say, okay, not going to challenge this. I'm going to make sure my visitor does not park inside the complex at all. And the visitor then starts parking immediately outside the building. Immediately outside the building in a public place, in a place where the residents of the building who are apparently offended by these statements are then looking at the vehicle possibly all day. Those who are walking past are looking at the vehicle possibly all day, instead of that vehicle being quietly tucked away inside a garage where no one is able to see it. I think that would be shooting oneself in one's own foot if the building was to take that approach. Okay. Oh, I said I was going to add something about the making of a complaint itself and those who perhaps have more power than others to make complaints. I said earlier that this owner, I don't think knows who these mystical residents are who are offended by this and who made the complaint. But I would like to think, as a strata lawyer, that the complaint has been brought to the attention of the strata manager by the strata committee, because the strata manager has very, very promptly issued this directive that the car needs to go, or the writing on the car needs to go if the car is to be parked in the garage. And perhaps it has been a committee member who has seen this car and this writing, and it's a committee member who was then able or felt themselves able or empowered to give that instruction to the strata manager to do something about this, to send this email off to the owner. If it was just a resident, a non-resident, a resident non-committee owner, so an owner-occupier but not on the committee, who saw this car and felt offended by it and wanted something to be done about it, I don't know that they would have had the same power to direct the action of the strata manager. It's reading between the lines or looking behind the scenes here, it seems to be a case that because a committee member or a number of committee members have seen this and have been able to give this directive, it's all happened very quickly, whereas somebody else not on the committee would not have that kind of power. And I don't think that's right. I don't think that's fair. And I think it's a very good example of why what I say consistently here on live and on the podcast, and I said it in an AGM a few nights ago, why our strata committees should be making decisions in meeting. And if action was to be taken and these it was a threatening email that said, if you don't have the writing removed, have the car removed, there will be further action. Before something like that is sent out, I think it's important for a committee to meet, have a formally convened meeting with notice of meeting, an agenda item. It's published to all owners. The notice goes out 3 days before the meeting is to take place. Owners can have a say. They can express an opposition if they want to the resolution. They can attend the meeting and listen in on the discussions of the committee, and then a decision is formally made on whether we want to, whether we need to, whether we think legally we can take this kind of action. All of that happening in a much more formal, much more considered environment where somebody's taken a breath before they've fired off an email. Bill and Ben saying exactly, ask where is the decision to go down this path. So I think the assumption is that it's a committee member has seen this, or more than one committee member, and the instructions be given to the strata manager and they have just followed that instruction. So I think a warning there to our strata managers as well. And look, maybe this did happen in this circumstance and the strata manager was acting under the express instructions of the committee. But our strata managers to be able to say, whoop, halt, cool your jets for a minute, hold your horses here. I hear you. Maybe the strata manager has an immediate view on whether this is a breach of a bylaw or a breach of the Act, but ultimately important to be encouraging your committee members and your owners who are coming to you with these concerns. We need to have a meeting, we need to have a discussion, we need to have a resolution about how we best proceed with that. Because sometimes you end up down a path that's not the correct path, not the most advisable path, and it's hard to go back once that's happened. John is saying strata doesn't alter the normal rights of property ownership that house owners have. This is one of the issues flying around in my mind this afternoon, John, when I was thinking about this. No problem with somebody parking a car in their driveway, in their house with political slogans on it. No law that I'm aware of that stops people from doing things like that on a public street. One thing I did come across that some of you in WA may remember, I didn't write down what year it was, I think some years ago now. Do you remember the wicked camper vans? Wicked camper vans that would have quite sexist, I think it's not unobjective to say, sexist slogans on them. And apparently, I didn't know this at the time, but apparently the WA government intended to or did pass some legislation that prevented not just wicked camper vans, but prevented people from having such slogans on their vehicles. And I think the legislation went to sexist, racist, violent comments and commentary or slogans, and banning those statements and slogans from vehicles, and it came about through the wicked camper vans and all the media attention that was getting. So I could only find that the WA government had done something about that. I didn't click through to have a look at the legislation. But aside from that, I couldn't find anything that would stop people from having these kinds of slogans on their vehicles. And I've seen them. I don't know if the rest of you, I've certainly seen them around in different contexts and different times, people driving cars around indicating what their views are. I do want to come back to Henry's point about hate speech and inciting hate speech and that kind of material, that there may well be Crimes Act provisions that deal with that for sure. Bridget is saying, agree that strata managers should be redirecting to the correct process in handling a complaint of this nature. Yeah, and I think you've got to check your own bias. I think it might be fair to say, check your own unconscious or conscious beliefs or your own emotion about a particular issue. And these issues, I'm not going to sit here and say, take purely legalistic approach, we're all robots. No, we're humans. And we have emotions about these things. And we have views about political issues and about human rights. And we have strong, often very strong beliefs and strong reactions. People will have strong reactions when they see something like this. And I hope it's not a case of the strata manager necessarily getting, and indeed the committee members getting caught up and getting wrapped up in that emotion, which is so easy to do, and forgetting about that formal process. So when you are committee members or strata managers, even owners, just communicating with people, when you are in those situations of high emotion, recognizing that and then immediately attempting, and I say this from experience, immediately attempting to regulate that emotion, taking a breath, recognizing you're going to be emotional, that, yeah, you do have a dog in this fight, you do have a view on this, and you've got to put that committee member hat on or that strata manager hat on and make sure that you're following those formal processes. That's why they're there. That's why the processes are there, to help you get through those sticky issues. Glenn is saying wicked camper vans with offensive slogans would be banned from being registered in all states and territories under a plan signed off at a national meeting of Transport Minute. National meeting, okay. So it sounds like that went national, Glenn. Whatever I was reading, it was legislation proposed by the WA government at the time. So interesting. Thank you for that update. Yeah, Stephen's saying perhaps it's the person's placing the rubbish, etc., that are a danger to the complex. Yeah, so if you're just tuning in and you didn't hear me earlier, the owner at the centre of all of this, the owner who owns the space where the car is being parked, there seems to be now some activity that's happening, retaliation, retribution, I don't know what it is, but there's rubbish that's being thrown on that person's back terrace, and the power to their garage was cut. Not legal avenues, I want to say, not legal avenues, and not the way to deal with these types of frustrations. Google, yeah, don't Google wicked camper vans. No. Thank you, Bill and Ben. John says, well, possibly the fearful need to stand up and call for reason and for the behaviour to stop. Yeah, well, I can tell you now that this person who is experiencing this behaviour is not a shrinking violet. And there's a reason why, well, this person was confident, let's say, this person was confident enough to share their story with me and to allow me to share it here with you. In all of our excitement, I have no idea what time it is. Oh, we're a few minutes to 5. That is what I wanted to say about that particular issue. Vivian is saying, is it also a risk the other occupants could be seen by others as guilty by association, for example, have the same mindset? Maybe that's what they're concerned about, Vivian. That could be what they're concerned about, and perhaps having the car parked outside the property is maybe the concern. I'm not sure that gives anybody an avenue to pursue an avenue in the law to take the steps that are being taken by saying remove the vehicle from your own property. But yes, Perhaps that's where the concern is coming from. All right. Thank you to that owner. You know who you are for being brave and willing to share that with me and to allow me to share that with everybody who is here today. I share it because these things may happen, may be happening in your own communities. These questions of how far does our right as an owners corporation to regulate what goes on inside an owner's own property, how far does that extend? And I can tell you, it extends a fair way. It really does extend a fair way. We were just talking about, can we have a bylaw that stops people from charging e-scooters in their own apartments? Um, perhaps is the answer to that. We have bylaws absolutely that regulate how people renovate their homes and when they do it, the parties that they have and the noises that they make and how they shower, whether their pipes are too noisy, or all sorts of cooking smells and smoking. Smoking is the big example of just how far our interventionist powers extend in Strata. They do extend a long way. I don't think they extend as far as this building in today's example thinks, or some members of this building thinks that they might extend. I am wrapping up. Cheryl's saying thank you. Thank you, everyone, for being here. And indeed, as Cheryl says, everyone have a great weekend. Thank you for joining me here in my Sydney abode. I'm going to be here, as I said, for a week. I've got my regular quarterly catch up with other women business owners next week that I do in Sydney every now and then. Looking forward to that. It shall be a busy week indeed. Entertaining as always, says Bill and Ben. Oh, look, I'm here because I'm entertained. You entertained too. That works out well. Thank you very much. Enjoy your weekend in Strata. Bye for now.